Welcome everyone, and thank you for joining us today. My name is Nicole Seedorf and I'm with the Iowa Department on Aging. If you have any questions today, we're going to ask that you raise your hand using the system online, and we have everyone muted at this time. We will unmute you if you raise your hand to ask any questions. And right now I'm going to go ahead and turn it over to Scott Hartsook and let him introduce himself and get us started.
Okay, thank you, Nicole. Yeah, I'm Scott Hartsook. I'm a lawyer with Iowa Legal Aid. I work with our legal hotline for older Iowans. And what we're doing today, this is actually this kind of a second part of a Medicaid series. We did both a webinar and ICN seminar back in October that I kind of did Medicaid 101. And so this is the follow-up to that. And basically what the format of this is going to be is just a bunch of scenarios of various fact situations that arise every once in a while, and we're going to talk about how to deal with those. So before we do that, though, I thought, in case there are people that did not attend the October seminar, and some of you might remember in October we had a sound problem, and so we redid this in December, the Medicaid 101. So what I want to do first is kind of start out, just go through some of the general Medicaid stuff, just to get people back up to date about the issues. Okay, so this first slide is, these are the general Medicaid rules that we've gone over before. You must meet the level of care, meaning you actually need to be in a nursing home and get nursing home level of care. Your income has to be less than $21.63 per month, and that is going up in 2015. And I actually heard today through the grapevine that new figure is going to be $21.99. I'm not sure whether that's accurate or not, but that's what I've heard. And then if you're over $21.63, you can actually still be income eligible by setting up a Miller Trust. And we'll talk about Miller Trust a little later on. The third requirement is that your non-exempt resources have to be less than $2,000. So, we're not talking about the exempt resources, including your home, a car, funeral plans, things like that, furniture. But if you've got more than $2,000 of cash in the bank, then you're not going to be eligible for Medicaid. And then you have to need care for more than 30 days. So those are the general rules for eligibility. And then, as you know, what happens, you file your application with DHS, you tell them what all your assets are. The general rule, if you're married, is that DHS will allocate 1/2 of the resources to the person in the nursing home and the other half to the person outside of the nursing home, who we call a community spouse. So if you have $100,000, the person in the nursing home is allocated $50,000, and he has to spend that amount down to $2,000 before being eligible. And there are two exceptions to that general rule. One is that the community spouse gets at least the first $24,000. So if your joint assets are only $30,000, the person at home gets the first 24, the person in the nursing home gets the remaining 6. So you only have to spend $4,000 before being eligible. Then there's also the maximum amount for the community spouse, which is $117,240. Again, that's last year, and that should be going up some. And I think Katie sent you out some information before, and I actually have an incorrect amount for those assets in our first scenario of $115,920. The actual amount, the correct amount, is $117,240. So the Medicaid application is denied until the person in the nursing home gets the assets that are attributed to them spent down to $2,000. In many cases, however, appealing that initial attribution of resources allows you to increase the resources that are going to be allocated to the community spouse. And so we're going to go over this little example. We went over this in October, but I want to go over it again just to show you how it works real quickly. So we have husband and wife here. They're both 85. They both have Social Security income of $1,000 a month. They own a home, a car, and each of them have their own separate savings account. So let's assume the husband goes in the nursing home and wants to apply for Medicaid. What they do is they file the application for Medicaid. They put all this information on the application, and here's what DHS will do with it. First of all, First of all, they're not even going to worry about the home and the car because those are exempt assets because the wife is going to continue to live in the home and she needs the car to get around. So regardless of how much those are worth, that home could be a $2 million mansion. The husband could potentially still be eligible for Medicaid. And for people in Iowa that live on farms, if your home is on a farm, then the entire piece of real estate that you actually live on is exempt. So if you own a whole section of land, 640 acres, and you're living on it, that whole thing is going to be exempt property, even though it might be worth a few $1 million. Same thing with the car. The car can be a $10,000 car, as in our example, or it could be a $80,000 Jaguar. Their first car is going to be exempt. What DHS will look at, though, are the savings accounts and any other kind of financial assets. So checking accounts, savings accounts, CDs, stocks and bonds, mutual funds, retirement accounts, money you have under the mattress, any other asset you have. It could be a rental property that you're renting out to somebody. So anything that you have that is available to be sold and could potentially be used to pay for the husband's care is going to be an accountable resource. So in this case, it's real simple. They just have these two accounts. So DHS, they put those two accounts into one big pot of money because they don't care which spouse owns it. This money could have all been the wife's money, but it doesn't matter since they're married. So they put it into one big pot of money, $90,000, then they split it up using the general rule of 50-50 split. So he gets $45,000, she gets $45,000. And then what happens is DHS is going to send a denial letter because the husband is allocated more than $2,000. He gets $45,000. So until that's spent down, he is not eligible for Medicaid. And so what they need to do at this point, is appeal that decision. And you appeal the decision because it is possible that on an appeal you can get more assets. And here's where it kind of gets a little more complicated because there's one set of rules for people who have been in the nursing home since February of 2006. There's a newer rule which is less favorable to the person for people that go in the nursing home after February 2006. So the old rule, what they do is they consider an amount which is, why is it just going?
Sorry. I thought I could do it. All right, go.
Okay. So you see up there the wife, $2,931. So that's what DHS calls the minimum monthly maintenance needs allowance. And what that is that's the amount of money we would like the wife to have to pay her monthly bills if they in fact have that much money. Now these folks don't because they only have a couple $1,000s of Social Security income. So they're less than the $2,931. But we don't look at his income. We only look at her income under the old rule. So we would like her to have $2,931. Instead, her Social Security is only $1,000, so she's $1,931 short. So if you appealed the denial of Medicaid eligibility, the administrative law judge is going to say, how much does it cost the wife to go out and buy an annuity that would pay her $1,931 for the rest of her life? And whatever the cost of that annuity is, that's how many assets we're going to allow her to keep and still allow him to be eligible for Medicaid. So the cost of an annuity to pay her $1,931 a month for the rest of her life is way over $100,000. So as a result of the appeal, the wife gets the husband's $45,000. So she isn't just stuck with her initial $45,000, she gets the whole thing. Now, she doesn't actually have to go buy an annuity with that money, but she is allowed to keep it and do with it what she wants. And then what's going to happen under the old rule is you're going to look at his income, which is $1,000 a month, and we're going to allow him to keep $50 of it because everybody in the nursing home gets at least $50. Some veterans get more than $50, but the general person is going to get $50. So that leaves $950. And we're going to allow the wife to have that $950 also. And the reason for that is we would like her to have $2,931, remember, but she only has $1,000 a month income, so she's $1,931 short. So she gets to keep as much of his income as is needed to make up that difference of $1,931. So in this case, it's only $950, but that's all she's going to get. So the result under the old rule is she gets all the assets, and she gets almost to keep all of their joint income except for the $50 that he gets. Now the new rule is a little different, and it's not near as good for, in this case, the wife. Because under the new rule, what they do is they look at the income first, and they decide if she gets to keep any of his income. And so the same thing happens. He keeps $50, so there's $950 to be diverted to her. She needs that $950 to get her up closer to the $2,931 that we talked about. So she's going to get all that. So the same thing under the old rule and the new rule. But when you look at the assets under the new rule, what happens is you go through the same process, really. You put the $40,000 and the $50,000 into one pot of money, which is $90,000. You split it out 50-50. But then when you appeal that, what the ALJ, the Administrative Law Judge, looks at is they're going to say, we would like her to have the $2,931 a month. She has $1,000 Social Security, but now she also has the $950 that she gets from her husband. And so instead of being $1,931 short every month, she's only $981 short. And the cost of the annuity to pay $981 a month for a woman who is 85 years old is only about $43,000. So as a result of the new rules, she does not get to keep her husband's $45,000. So she gets his income, almost all the income, but doesn't get any of his assets in this situation. So it's not near as good as the old rule for her. Okay, so once you go through that process, and most people we're dealing with now, the new rule applies. Once you go through the attribution process and it's determined that the husband is going to be allocated that $45,000, then a lot of people think that, well, we just got to pay for his nursing home for the next 8 or 9 months, and then that will be spent, and then he'll be eligible. We have a question. So somebody raised their hand.
Yes.
Hi.
Can you hear me?
Yeah, go ahead.
Yeah, thank you. So I just want to be sure I'm following here. So you said that she doesn't get any of his $45,000 because she already has $45,000 and it only costs $43,000 to get that annuity?
That's right.
Okay.
The cost of the annuity is $43,000, so she doesn't get an additional $43,000 to go buy the annuity. Instead, since she already got $45,000 to begin with, she has enough to go buy an annuity if she wants to get her income up to where we want it to be.
Thank you.
Okay. So you go through this process, and you think you got to spend the $45,000 on the nursing home care, but that's not quite right. What you have to do is spend it down somehow. And so we're going to go to the next slide. And so spending down resources. Here's a list of things that you could spend the husband's $45,000 on so that you can get him eligible. So you can pay debts of either spouse, you can buy funeral plans for both of them, you can buy exempt assets. Remember, they had a $10,000 car. She could go out and buy a new car worth $30,000 to spend it down. She could repair her home. That's going to be an exempt asset once she puts money into her home. She could go on vacation. You can buy stuff for the person in the nursing home that they need. So you can, you basically just have to get rid of that money by spending it on something that benefits either the person in the nursing home or their spouse. Basically, the main thing you can't do is you can't give the money away and then become eligible for Medicaid. Although in some situations you can. For example, if you had a disabled child, you could actually give the disabled child the husband's $45,000 and he would be eligible for Medicaid. But those are very, very specific rules, and they're fairly limited. So the general rule is you can't give things away in order to be eligible for Medicaid. And then the other thing to remember is when you're spending money down, because of the way the rules work, it's often advisable to not make those expenditures until after the person is in the nursing home. Because if you make them before, that reduces the amount of money that you're splitting up equally between the husband and wife. So if you spend all this money down first, even though they're on things that benefit in this case, the wife, it's going to protect less cash for her. So it's better to not make those expenditures until after the husband goes in the nursing home, and then you can spend his money down on things that benefit the wife and still have the $45,000 of cash protected for her. Okay, so we're not going to talk about this. This is just some general Miller Trust information that we gave you. But we're going to get on to the scenarios, because that's the fun part of this presentation. Okay, so I think all these have been sent out to you. So hopefully you've read through them and you've determined what you think the answers are, and what the rest of our presentation is going to be here is going through these seminars. And I'm going to tell you what I think the answers are, and hopefully your answers agree with mine. And if they don't, please raise your hand, and we'll figure out what's right. So this first one, and I have to tell you, we get a lot of calls at the hotline from lawyers around the state who are dealing with Medicaid problems, and most lawyers don't know a whole lot about Medicaid issues. And so a lot of these issues that I have here are actual questions that I've gotten mainly from lawyers, and especially this first one. So the first one is, husband's in a nursing home and their assets are $300,000. They're slowly dwindling to pay for his care. At what point should they apply for Medicaid to ensure that they don't spend more of their assets than they need to? And that's a very important question to answer, because I've seen lots of people who spend a lot more of their own money than they really need to. And once you've spent it, you can't call up DHS and say, oh, I guess my husband was eligible for Medicaid a year ago, so could you give me back the $60,000 that I've spent on his care so that I have that to live on the rest of my life? DHS is going to say, no, we won't pay you back. So you need to be sure you know when you are eligible for Medicaid so you don't end up spending more than you should. And the problem that people run into on this is, like this situation, $300,000. There'd be very few people who would believe that somebody with $300,000 is eligible for Medicaid to pay for the nursing home care. But depending on what the facts are, you could easily be eligible for Medicaid in this situation. So what this lawyer asked me, he says, would you apply when the value of their non-exempt assets equals double the community spouse's resource ceiling? So remember that amount this year is $117,240. So this lawyer was thinking, okay, well, the wife is going to get to keep that, so that means if you allocate the same amount to the husband, then that would be a good time to apply for Medicaid. But actually, if you know they're not, if you know they're not going to be eligible at that point when they have double $117,240, there's really no reason to apply them, because what that means is that the husband still has $117,000, and so he's not going to be eligible. So why apply? So what I normally tell people is, if you don't know whether you're eligible for Medicaid and you don't have access to anybody who could tell you whether you're going to be eligible, then I usually tell people to apply when they first go in the nursing home, because it's at that point in time where DHS looks at the assets that you have on the first day of the month that you enter the nursing home to decide how many assets the community spouse gets to keep. So if you have no idea whether you're going to be eligible, you might as well apply then. You'll go through the attribution process, and you will find out how many of your assets you have to spend down before being eligible. Now, for a lot of people that would be kind of a waste of time, because they're not going to be eligible if they have all this money. So the better thing to do is to contact somebody that can tell you whether you're going to be eligible. And one thing you can do is you can call our hotline, because I can tell you in 10, 15 minutes after finding out your situation whether you're going to be eligible, and then tell you what you need to do to become eligible. So in this specific example, you don't really know when they're going to be eligible, because even though $117,240 is the normal limit for the amount of assets that the community spouse can keep, it could actually be a lot higher than that depending on the income and the age of the community spouse. Or rather, it depends on her age and their joint income. So if the husband is going in the nursing home, and at that point the wife happens to only be 74, and they both have fairly low income, let's say they both get Social Security of $600, $700 a month, which isn't unusual for a lot of people, she could very well be entitled to that whole $300,000. So you don't want to wait until you get down to double the 117, because you may have ended up spending $60,000 to $70,000 that you didn't otherwise have to. So you can't just kind of have a set rule of when's the best time to apply. You actually have to know the facts to figure out how much the community spouse is allowed to keep, and then once you know that, then you proceed to spend down the rest of the money, assuming the husband's already in the nursing home, and then once that's getting spent down to around $2,000, then you can go ahead and apply, and he should be eligible at that time. Okay. So let's go to the next one. Couple has $100,000 to spend before husband's eligible for Medicaid. Can they buy an annuity for the wife that converts the assets into a stream of income for her, or would this violate the transfer of asset rules? Well, buying an annuity can, well, first of all, let's talk about who we're buying it for. You know, we got $100,000 to spend down, so what that tells me is that the $100,000 is money that was attributed to the husband, so it needs to be spent down before he's eligible. So one important point here is you don't have to spend that money on him. And in fact, you normally wouldn't spend it on him because he's in the nursing home and there's not a whole lot of needs that he has anymore that you need to take care of. So, you know, you can buy an annuity for the wife because you can spend his money on things that benefit the wife. So you can't just go out to your insurance company, though, and say, hey, I want to buy an annuity. Here's $100,000, I want to buy an annuity, because they're going to sell you some fancy, dancy annuity that isn't going to allow you to be eligible for Medicaid. They put kind of quite a few restrictions on annuities, and if you don't follow the restrictions, it is going to be considered a transfer of asset, and you're not going to be eligible for Medicaid. So you have to make sure that the annuity follows the rules, and basically the rules require that the annuity not be revocable or assignable, so that there's no way you can get at it. It also has to be actuarially sound, and it also has to provide for equal payments of installments during the term of the annuity. You know, it used to be people would do annuities which would pay them, you know, like $10 a month for 10 years, and then at the end of the 10 years it would pay out $90,000. And what people tried to do when they did stuff like that is they were thinking, well, I'll probably be dead before the 10 years is up, so it'll be my children or my spouse that get all that money from the annuity instead of using it to pay for Medicaid. So in response to those kind of actions, Congress set these rules that say you have to, if you got $100,000 for an annuity and it's going to be a 10-year annuity, the 10 years actually has to be equal to or less than your life expectancy. And it also has to be paid out in equal installments during the 10 years. So you know, you're going to get payments of $800–900 a month for the 10 years rather than having it all be paid as a lump sum at the end. And what this allows is that increases the income, and so from the government standpoint, it hopefully lessens the amount of money that Medicaid has to pay for your care. Okay. Next scenario. Daughter has been spending more than 15 hours per week for the past 3 years providing various services for her mother. The mother may be entering a nursing home in the near future, and she has $30,000 in the bank. Can mom give her daughter the $30,000 for all those things she's done for her in the past? And the general answer is no, and this actually comes up quite a bit. The way DHS looks at this is the daughter has been helping out her mother for the past 3 years because it was her mother and she was just being a good daughter, and that's what daughters do. And when she was doing those things, she was not expecting any payment for it. And so from DHS standpoint, all those services were basically gifts from the daughter to the mom. And so now if the mother gives the daughter $30,000, it's just a gift to the daughter, and you can't make gifts to the daughter or anybody else except your spouse, and still be eligible for Medicaid. So generally, you couldn't give the $30,000 if this is all we knew. Now, there are some situations if the daughter and the mother 3 years ago had sat down and made an agreement where, daughter says, Mom, I'm going to come over and do your laundry and cooking and clean your house and take you to doctors, and that's going to take about 15 hours a week, and I want you to pay me $15 an hour for that work. And Mom could agree to that. And the best thing to do is to put that down in writing, so that way there's not a gift here. Instead, Mom is just paying daughter for the services just like she'd have to pay somebody else for them if daughter wasn't there to provide for them. And so if they have a written agreement, and the agreement doesn't necessarily have to be in writing, but that's the best way to document it for DHS. Otherwise, they're just going to think that you're making it up. So, if you have this agreement in writing, you keep track of all the things you've done, and maybe Mom wasn't able to pay you at the time that you were doing it for whatever reason. Maybe she didn't have, some situations, Mom doesn't have $30,000 in the bank. All she has is her household furniture and a home. So at the time she goes into the nursing home, then she can sell her home and she has some cash then. And so she could use that cash to pay her daughter all the amounts that are owed under that agreement for services. Unfortunately, most people don't have those kind of agreements, so they're kind of out of luck. And then the other thing, too, on this one is, one thing that's often easy to forget there are certain exceptions to the transfer of asset rules. And one of them is you can give anything to a disabled child. So in this situation, if the daughter happened to be disabled, Mom could give her the $30,000 and it wouldn't have any effect on her eligibility. But again, that's a very narrow exception. It only applies to children. So if instead of a daughter, this had been a granddaughter doing this work, and the granddaughter was disabled, that exception doesn't apply because it only applies to disabled children and not grandchildren.
You have a question in the room.
Question. Okay.
Okay. So in this scenario, would she need to either be paying employment taxes in this situation, or would she have to issue a 1099 as though she were self-employed, or does Medicaid not really care about that piece of it?
Yes. I mean, if you're paying your child $15 an hour for doing work for you,
mm-hmm.
that is income to the child.
Mm-hmm.
And so I'm not a tax person, so I know when you're getting into doing work in a home, mm-hmm. there are certain rules you got to follow.
Right. I just didn't know
but if those rules apply to this type of work, mm-hmm. you would have to follow them.
Okay.
And that would be one way to show DHS that you did have an agreement.
Okay.
With your child to
okay.
pay for the services.
Okay.
Yeah. Okay. Next scenario. Client's in a nursing home. His income is $2,800 a month. Once he becomes eligible for Medicaid, $1,000 of his monthly income will be able to be diverted to his wife, leaving him with only $1,800. Does this mean he doesn't need a Miller Trust? Well, because you only need a Miller Trust if your income is less, or if your income is more than $2,163 a month. So in this situation, after the wife is getting that $1,000 diversion every month, his actual income is only $1,800. So yeah, somebody called me up one time and asked this, and I thought, well, that's a good question. As it turns out, he does need a Miller Trust, because the $1,000 that is being diverted to his wife is still counted as his income. And actually the diversion to the wife doesn't occur until you've actually been determined to be eligible. So to be eligible, he's got to do a Miller Trust because his income is over $21.63 a month. And then once he's determined eligible, that's when the diversions start. But the fact that the diversion takes your actual income down below $21.63 is irrelevant. So yes, he does need the trust. Next one is client is in a nursing home and has paid for his care for the past 4 years. It's now May 20th and she has only $200 left. She needs to become eligible for Medicaid on June 1st to pay a June nursing home bill, but she needs a Miller Trust established since her monthly income is $2,700. Should the client use her last $200 to go pay a lawyer to do that trust for her? And, you know, the best answer here is, yeah, you should always give your last $200 to a lawyer. Oh, okay. No, the real answer to this is yes, she should use her last $200 to establish the trust because you're not going to become eligible unless you get the trust set up. But, you know, I'm looking at this from a financial standpoint because first, it might be hard for you to even find a lawyer who will do that trust for you for only $200. Usually they're like $300 or $400 or $500. But here's what should be done in this case. You just delay your eligibility until July 1st. And that way, your income that comes in June, which is $2,700 a month, can be used for two purposes. You use part of it to put with your $200 in order to pay the lawyer to do the trust, and then you use the rest of that to, remember, a person in a nursing home, they can have up to $200 or $2,000 of assets. So if she became eligible on June 1st, and you know, let's say she didn't even need the trust, she'd only have $200 to pay for everything she's going to need in the nursing home for the rest of her life that the nursing home doesn't pay for. So it would be nice to get her actual assets up closer to the $2,000 limit. So by using her June income to both pay for the trust and to get her savings up to the $2,000 limit, then she's going to be better off for the rest of her life. And so now you're saying, well, what about the poor nursing home? If she's not eligible for Medicaid in June and this client's not paying for her care, is the nursing home just out for her care? And the answer is no, it isn't. Because once she becomes eligible for Medicaid, then out of her monthly income, she's going to get to keep $50. The other $26.50 goes to pay her nursing home care. But Medicaid has a rule that says if there is an unpaid medical bill, which includes an unpaid nursing home bill, then that $26.50 every month can be first used to pay those delinquent bills. And during the month that her income is used to pay delinquent bills, then Medicaid picks up the full monthly cost of the care for those months. So, you know, it'll take a couple months for the nursing home to get its June bill paid for, but it will completely be paid. Client will end up with close to $2,000 in her account, and she'll have the Miller Trust and be eligible for Medicaid. Next one, this client is in a nursing home. His monthly income is $6,000. Can he be eligible for Medicaid to pay his monthly $5,200 nursing home bill? Okay, well, the normal income eligibility standard for Medicaid is $21.63 per month, and apparently it's going up to $21.99. But a person with more income than that can usually be eligible by establishing a Miller trust. The problem is the upper income limit for allowing a Miller trust is $5,833. And so he's still above that. So is he just out of luck? And it kind of, again, depends on what the circumstances are. If, because there's even an exception for the 5833 limit for people who receive specialized care, such as in an Alzheimer's unit. So let's say this guy had Alzheimer's. What he might need to do, and this happens every once in a while, you know, some nursing homes just charge a flat rate for, you know, whatever care you're getting, and they don't charge more for Alzheimer's folks. Other nursing homes have special Alzheimer's units where they charge a higher rate, and so sometimes what you end up having to do is you'd have to move this person, and this doesn't make a whole lot of sense, but you'd have to move this person to another facility that charges more, so that the charge is more than his $6,000 of income. And then he can be eligible for a Miller Trust even though he's above the normal 5833 limit. And then another option here is, you know, with income of $6,000 a month, that's definitely not Social Security. The Social Security doesn't go up near that high. So you can also look at what that income is. And if it's some kind of pension, what you could do, and this sometimes has to happen, not real often, but sometimes, you know, he could divorce his spouse, or you wouldn't even have to get a divorce. You could do like a separate maintenance agreement. And by doing that, you can have what's called a quadro, which would split the pension according, you know, if they've been married for 40, 50 years, and you get this $4,000 pension. If you get divorced, your spouse actually gets part of your pension. So if he has a $4,000 pension, they could have a separate maintenance agreement that says $2,000 is going to go to her, $2,000 is going to go to him, and then that would bring his income down below the limit that would automatically make him eligible for a Miller Trust. Okay, client recently died, and his Miller Trust has $1,200 in it. He also has a prepaid funeral plan, and there's $800 left after they pay for all of his funeral expenses. So client's spouse would like to have the entire $2,000 to help her live on for the rest of her life. Is she entitled to a spousal waiver of estate recovery so she can keep the $2,000? So remember, Iowa has an estate recovery law that says if you have received Medicaid benefits and you own anything when you die, then what you own has to be paid back to the state. But if you are married at the time you die, then there's an exception where the assets that are inherited by your spouse can be retained by the spouse, and she gets a waiver of that payback until the time she passes away. So what this question really brings up is the fact that there's a distinction between a Miller Trust and a funeral plan. The funeral plan is subject to the estate recovery law. And so if this person didn't have a spouse, that $800 left in the funeral plan would go to the estate recovery office to pay for the Medicaid benefits. But he had a spouse, so she's going to be entitled to a waiver of that $800. The same thing does not apply to the money in the Miller Trust, because the Miller Trust funds are not subject to the estate recovery law. Instead, one of the requirements of the Miller Trust is that any money left in the trust at the time you die automatically goes back to the state as the remainder beneficiary of the trust. So the state gets it, they just get it through a different method. And for the state, it actually works out better because the waiver doesn't apply to it. So they're going to get the $1,200, the spouse is going to get the $800, and everybody's going to be happy. Okay, next one. Client gave $90,000 to her son 4.5 years ago, prior to entering a nursing home. She has paid for her nursing home care since then, but now is out of money. Will she be eligible for Medicaid? Well, again, the first thing you probably want to look at is, was the son disabled? Because if he was disabled, then you can give anything you want or anything you have to a disabled child, and it doesn't violate the transfer of asset rules. So this son was not disabled. So the best thing for them to do, because the transfer of asset rules says that if you give things away within 5 years of needing Medicaid, that you're going to be ineligible for a period of time. And so this gift was within that 5-year period. And so if they didn't do anything, she's going to be, and they just applied for Medicaid, she's going to be ineligible. So what they should do instead is, you know, the gift was 4.5 years ago. So they're 6 months short of being outside that 5-year limit. So if the son is smart, he'll hopefully have that $90,000 still, and he'll pay for his mother's care for the next 6 months, which might eat up, you know, half of that $90,000. But at least by doing that, then at the time she applies, it will have been more than 5 months or 5 years after the gift, and so he's going to be allowed to keep the remaining $45,000, and she'll be eligible for Medicaid. Okay, client is in a nursing home and has a piece of non-homestead real estate that is assessed for $100,000, been trying to sell it for $100,000 for 8 months, but no one's bought it. He has no other assets and owes the nursing home $25,000. Can client sell the property at auction to get rid of it and pay his nursing home bill? And the answer is yes. There are a couple rules you got to follow when you do an auction. You have to have tried to sell it for fair market value, whatever fair market value is. But if it hasn't sold, then you have to be sure that the auction is a legitimate auction. It's advertised just like auctions normally are, and if you do that, then whatever it brings at the auction is going to be considered the fair market value for that property. So, you know, it would not be unusual to, you know, for this property to be bought at an auction for $50,000. Maybe that's because the house isn't really worth more than $50,000, or maybe it was just because nobody was really interested in buying it at the auction for any more. But you sell it for $50,000, you pay off the nursing home $25,000, you've got $25,000 left to spend down before you're going to be eligible. I want to go back to the last scenario. You know, we talked about what the son should do if he was smart. But lots of times people don't have very smart sons. And the son may have spent that $90,000 as soon as he got it. And so, you know, does that mean that this client's just out and she's not going to be able to pay for the nursing home, and the nursing home's going to kick her out on the street, and she's going to die in this below zero weather? No. Because Medicaid has hardship exceptions. So if she doesn't have any other way to pay for her nursing home care and without Medicaid, then she's actually going to get Medicaid benefits. So we don't really have to worry about her getting cared for or the nursing home being paid. But in that situation, what will then happen is there's the other 5-year rule that says if you give things away within 5 years of needing Medicaid, then the state will go after the person that you gave the money to. And so, the state will take care of this woman, but then it will turn around and go after her son for whatever they have to pay for her up to the amount of $90,000. And that's why if he's smart, he would just pay for 6 months of care, because that way he would at least be able to keep $45,000. But if he's already spent it and the state has to start Medicaid right away, if they pay more than $90,000 in Medicaid benefits, then they're going to go after him for that money. Okay, client lives on a farm. Clients live on a farm worth $500,000. Husband will soon need to move to a nursing home, and his wife, who never really liked living on the farm anyway, wants to sell the farm and move to town. What should they do? This is an actual couple that I talked with one time. She was planning to sell the farm and move into town, and before he was even eligible for Medicaid. And so the answer to this is she should stay out there on the farm, even though she really doesn't want to live there, until he's in the nursing home, has applied for Medicaid, and is found eligible for Medicaid. Because if this is all they have, just the farm, and like a lot of farmers, they have a lot of wealth and land, but that's about it. So as long as she's living on the farm, that is considered an exempt asset. So if he gets eligible for Medicaid, then after that point, she is able to do what she wants with her homestead. So at that point, she could sell the farm, collect the $500,000, move into town like she wants to do, put that money in the bank, and it doesn't have any effect on his eligibility. And she's going to have that money to live on the rest of her life. But if she sells the farm before he becomes eligible, then when they apply for Medicaid, what do they have? They don't have an exempt farm anymore. They have $500,000 in the bank. So they're going to split it up, 50% to her, 50% to him, and she's going to be out a lot of money. We got another question.
We do. Okay, so for the farm, does that just include the land and the house? What if they also own a tractor and a combine? Do they need to sell the tractor and the combine, or is that part of the farm as a collective?
Well, it's not part of the real estate. So you got to look at that differently. It depends on what you're doing with the farm.
Okay.
If you're farming the farm, so you're using your tractor and stuff,
right,
then the machinery is exempt property too.
Okay.
But if you're just
sitting,
living on the farm, your tractor's been sitting there idle for 10 years, and you're renting out the farm to a neighbor, then the tractor is going to be an asset that has to be counted. Okay, here's another one I actually did one time. Client lives in a mobile home worth $10,000, and they have $200,000 in cash. Wife will need nursing home care soon, but husband will also probably need to move to an assisted living, because I think when I talked with these folks, they were both like 94. So what can clients do to help ensure that the husband will have enough assets to keep him in assisted living as long as possible? Because if she's going to be in the nursing home and he's going to be in assisted living, they could be paying out $10,000 a month, and they're going to be out of money in a year and a half, and that's what he was concerned about. Okay, so because again, if they just moved her directly to the nursing home and then applied for Medicaid, the Medicaid folks are going to say, well, you got $200,000. He gets $100,000, she gets $100,000. Hers has to be spent down before she's eligible. So what I told them they could do, and I didn't really think they'd do this, but they actually did, is I said, sell your mobile home for $10,000, go move into a condo that you have to pay $210,000 for, and then move mom to the nursing home. Get her eligible for Medicaid, which she'd be eligible because all their money is now in an exempt asset, an exempt homestead. And then once mom becomes eligible, then he is allowed to do with his homestead what he wants. So he can then sell the condo and probably have to pay realtor fees, but he still has $200,000 left. And he can move to an assisted living place, and he has $200,000, which should keep him there for quite a few years. Client has no spouse, owns a farm worth $1 million and needs to go into a nursing home. Can client give anything to his children, or must he keep everything and possibly have to spend it all on nursing home care? And what this scenario illustrates is that unlike people with few assets, wealthy people can actually give assets away and still be eligible for Medicaid. Because what these folks have to do is they basically say, well, how much is it going to cost me to pay for my care for 5 years? And so let's say that's $400,000. You know, what they can do is he can give his kids $600,000, keep $400,000. That pays for his care for 5 years, and so at the time he applies for Medicaid 5 years from now, he's passed that 5-year look-back rule, and he'll be eligible for Medicaid, even though he gave $600,000 away. Okay. Here's the last one, which is good because we only have about 2 or 3 minutes left. So client has been in the nursing home for 7 months and has not paid anything for his care. Family members are taking care of his finances, but they will not get the appropriate documentation to DHS to get Medicaid approved. It is also clear that probably the reason they're doing that is the family members have been using the client's money for their own expenses. What can the nursing home do to ensure payment? Well, they got various things they can do. One is they could involuntarily discharge him for non-payment. And the problem with that, though, is to discharge somebody from a nursing home, you have to find an appropriate placement for them. And if the person's not paying their bill, there's probably not going to be another nursing home that'll take him. So that's not really a very realistic thing to do. And the nursing home probably doesn't want to discharge him anyway. They just want their money. So another thing you could do is you could file a complaint with the DHS Elder Abuse Hotline, and what DHS should do is investigate and find out that the client's family is misusing his money. They can then refer it to the local county attorney, who will have a conservatorship and guardianship set up, and then the conservator can get the Medicaid application going, get that approved, so the nursing home's taken care of, and then they could also go after the family to get whatever money there is back. The problem with that is DHS probably would not do that because they consider the person being taken care of in the nursing home even though they're not paying for their care. So that is usually not a good option either. So the best and quickest solution for the nursing home is to file a petition for guardianship and conservatorship itself. And of course they're going to be out a little money to do that, but you know, if this client has money, the costs that the nursing home incurs to get a conservatorship set up can be paid out of the client's funds. And then as a result of getting the conservatorship set up, again, the conservator can get the Medicaid application going, get it approved so the nursing home's not losing any more money, and then the conservator also can go after the relatives to recover the misspent funds under Iowa's new elder abuse statute. So So unfortunately, what happens in these cases, it seems like nursing homes usually take the involuntary discharge route, even though that doesn't make a whole lot of sense for them or anybody else. And what they should be doing is getting as a creditor of this person, they should be setting up a conservatorship so that everything can get straightened out. Okay, so that is it. And anybody have any question in the last minute or two? Okay, well, we thank you for coming then. And if there are lawyers on this presentation, we have applied for CLE credit. We're not sure it's going to be approved, not because of the material presented, but just because sometimes the state entity that approves it will not approve things if things are not specifically directed mostly to attorneys, and that's really not what this was set up for, even though it's appropriate for attorneys. So we'll have to see whether it gets approved or not, and hopefully it does. Same thing with the one back in October. We're still waiting for credit for that, and not sure if we're going to get it or not. So thank you for listening, and we might do another one of these this year. Okay, bye.
Thank you.